At Law Development Center Court, filled with relatives, no pleaders, and supporters, MP Francis Zaake appeared in the dock before Magistrate Martin Zake's legal team asked court to grant him bail by presenting Alan Sewanyana, Nyeko Delika, and others as sureties. The prosecution objected, arguing that some of the presented sureties were not substantial and asked court to deny Zaake bail. At around 3 p.m., Magistrate Martin returned and granted Zaake bail.
Application presented by Honorable Zaake Francis, the Honorable Member of Parliament for Mityana Municipality. This application was brought through his lawyers, Mr. Kiza Aaron, Elias Lukwago, and Tusime Kato on the 22nd day of July 2024. The accused stood charged with the offense of careless or inconsiderate use of a motor vehicle contrary to Section 119 of the Traffic Road and Safety Act, driving without a valid driving permit contrary to Section 35, 1 and 176(1) of the Traffic and Road Safety Act, and disobedience of lawful orders, which was contrary to Section 104 thereof. I shall not dwell on the particulars, but the accused, however, denied the charges. Submissions. Counsel Kiza Aaron applied for bail on behalf of the accused. He urged that the charges against the accused persons were minor traffic transgressions, on the basis of which the accused person's liberty cannot be circumscribed. That the offenses don't entail an element of personal violence. The accused is a very responsible citizen, and it is true, as stated in the charge sheet, that the accused is a honorable member of Parliament. Counsel then presented 3 sureties in the following manner. Surety number 1, Honorable Masaba Karim, Member of Parliament, Industrial Division in Mbale City. He produced an employment identification card and national identity card for scrutiny of this court. Surety number 2 was Elias Lukwago, the road mayor of the city, which he said this court, which harbors this court, as stated by counsel. He then submitted the national identity card of the landlord mayor. Surety number 3 was Mr. Katerega Hamza. He said he has a national identification card and he was born on the 25th day of May 1990. Counsel then submitted that the sureties are substantial. He prayed that they are deemed so, and this honorable court grants bail to the accused person on that basis. At this time, counsel realized the need to provide the phone contacts of the sureties as 0759 009 000 03948 24 700 for Honorable Masaba Karim, and 0754 666666 for the road mayor, then 0705 974 325 and 079237329 for Mr. Katerega Hamza. He also prayed to drop the road mayor as one of the legal counsel and adopted him as a surety. Arising from the above, Counsel Kato Tumsime, as co-counsel in his submission, reminded this court that the credentials of the sureties in regard to their age, work, and residence, character, had been properly laid before this honorable court. He prayed that this honorable court finds the surety substantial and uses its discretion to grant bail, preferably non-cash, since it was getting late for the banks to be open. Prosecution response: this application was objected to by the Land State Attorney, Mr. Adut Timothy, that other than the defense team presenting the work IDs and national IDs of the respective sureties, they have not provided the photocopies, even when the photocopier were just across the road. They did not produce any local council letters to establish their residences of the said sureties. For that matter, he pleaded with the court that the national identification of the sureties are for upcountry, where non-known village locations of the sureties were alluded to by the defense team. He prayed for the defense team to provide with him proper documentations for him to verify before court makes an informed decision. Counsel Tumsime objected to the Land State Attorney's prayer and argued that verification of the documents is unconstitutional, since there is no law that permits the state to verify the identifications of the sureties. In reply, the state tasked the defense to provide the law, which then bars him to verify identifications as a matter of due diligence. He reiterated his request. The issue was for determination was whether the state attorney can be accorded an opportunity to be provided with the documents from the defense in order to respond to the bail application. In this case, it is not in dispute that the defense team did not produce any documents to be relied on for bail application. The only items provided is the work identification card of Honorable Member of Parliament, Mr. Karim Masaba, of the Industrial Division of Mbale. His known address, if any, within Kampala in the jurisdiction of this Honorable Court was not provided, including an identification of a letter from the local council chairperson. The second surety was the Lord Mayor, His Worship, Elias Lukwago. It is only his national identification card which was provided and nothing else. The third surety is Mr. Katerega Hamza. His residence within the jurisdiction of this court was not revealed, but looking at his national identification, it read Ntikide Butega in Mitiana district. Unfortunately, the defense counsel did not bother to have at least the documents, the items photocopied for this court and the state attorney, to enable him not only to have copies but also to respond to their bail request, and yet even the relationship of the sureties to the accused persons had not been revealed. Determination without delving in the merits of the application. This mini issue is on the concept of fair trial in regard to disclosure of documents to be relied on in a trial by the parties to a case. In Uganda, it is a matter of right, though coupled with some limitations. In the case of Sun Yun, Kong Kim, and another Master Attorney General, the Supreme Court said a right to fair hearing contains a right to pre-trial disclosure of material statements and exhibits. In an open democracy, courts cannot approve of a trial by ambush. The right to George Musisi, Benjamin Katana, Tumsime Kato, Honorable Malende Shamim, Mr. Magellan Kaziwe, Kikome Kasol, and Kalule Fred. Counsel Chiza submitted that they reiterate the submissions on the record. He presented three sureties: Honorable Masaba Karim, a Member of Parliament of Uganda, Mr. Katarega Hamza, and Honorable Sewanyana Alan, Member of Parliament representing Mashindi West. All the sureties presented the copies of their national identifications and letters from their area local councils. The state perused the same and made a reply in objection to Honorable Mr. Sewanyana because of his being an accused at the International War Crimes Division, where he is battling with criminal charges. In his submission, he opined that since he is battling with charges, he might be unable to have the accused person mobilized to attend the court. He also objected that the accused has residence in Mitiana, which might be hard to have him return in the court, since he has not proved that he hails from anywhere within the Judicial Reasonable Court, which could offend Section 772 of the Emergency Courts Act. The defense team, in response, Mr. Musisi George argued that Section 772B, as relied on by the state, does not wipe away the powers and discretion of its courts in granting bail, and as such, it is a mere directory. Further, that even when Sewanyana is battling with criminal charges, he remains a presumed criminal whose innocence is upon the proof of his guilt. He prayed to this court to overrule the state. Finally, Mr. Kalule submitted that once an accused has substantial sureties, the status of the accused is less to be considered. In this case, since the state has not disputed the two sureties, the court should be pleased to grant bail, he prayed. Determination: I have internalized the above submissions from both sides and has submitted any person charged with criminal charges is presumed innocent, and therefore, on presentation of sufficient and substantial sureties, the court exercising her judicial powers can grant bail. The question is one of substantiality of the sureties. Only Mr. Sewanyana was doubted by the land state attorney. The fact that he is a honorable member of Parliament has not been disputed, but the state only questioned his potential as a surety because of having criminal charges in International War Crimes Division. I take note that by him being before this court, he must be on bail from the same court. This is a testimony that the court trying him still believes in the law that he is still innocent. Therefore, pronouncing him not substantial on that reason by this court would amount to convicting him for the charges not before this court. For that matter, I disagree with the Land State Attorney and agree with the Council Mr. C that he is substantial, even when he is grappling with those charges. Having proved his residence within Kampala, it is not disputed that he is a member of parliament in Kampala and all the other two sureties are his colleagues, but also have residences in Kampala. In my view, they are able to ensure his return, especially that he works within Kampala. For that matter, I allow the bail application and grant it on the following terms. The accused is granted the cash bail of 200,000. The sureties each is to execute a bond with this honorable court of 10 million, not cash. Matter is adjourned to 26th of August for mention.
Zaake faces charges of careless use of a motor vehicle, driving without a permit, and disobedience of lawful orders. In the same court, 9 suspects charged with unlawful assembly were also raised on a cash bail of 100,000 shillings each.
Of course, we are delighted because bail has been granted to all the accused persons. For Honorable Zaake, he's required to pay 200,000 shillings cash, and each of the sureties, that is 10 million shillings non-cash. But for the rest of the 9 accused persons, it's 100,000 shillings cash and 500,000 shillings, which is non-cash. We want to, pay respect to actually the judicial officer that handled this matter, because they are all operating under fear. So if we still have a judicial officer who can stand up and say that I'm going to write this ruling according to the law and it follows the law to the letter, we actually respect that, and we call upon even other judicial officers and all Ugandans to join this cause.
In which were illegally arrested from this very headquarters of ours. It was uncalled for because they didn't inform us, they didn't write to us whatsoever, but they just made the arrests that were really illegal. They took our things. For example, my car is still at the headquarters of police, CPS, and they spoiled it. But it has been very unfortunate that they instead put traffic offenses on me, whereby I had a driver got out from the gate, and that's where they told me from up to CPS. So all that, we condemn it. It was unnecessary, and also the situation we found in prison, especially with our people that were imprisoned there for over 4 years. They are there, they're in a very, very sorry state, and we have come out energized to fight for them, to fight for the political prisoners, to fight for the others, especially the young people who protested. We thank everyone who has stood with us. We thank our party. We thank the lawyers. We thank the president himself, His Excellency Kyagulanyi Ssentamu, for being behind this cause. And we know that we shall not back down. We shall keep on pressing, and we know we shall overcome one as a country. Thank you.
Did come to court here for the second time after our colleagues, members of parliament, councillors, and members of our party and so on, were brutally picked up as they came to attend a press conference at our party headquarters. Something which is not an offense anyway. They charged them with all manner of things, unlawful assembly, traffic offenses, and so on. We are glad that the second time we have come for their bail hearing it's been granted. The state was trying to derail the process, saying we need 2 weeks, they need 2 weeks to be sure and verify these national IDs. We said, can we be serious, surely? How do you say you need 2 weeks to verify a national ID of a member of parliament, of a Ugandan citizen? You're the government. Call the NIDA people, let them verify. Do you have this ID number and that kind of thing? And we are glad that court said, no, let's deal with this matter today. And eventually our colleagues have been granted bail because they committed no offense. And that's why they have been strong through this entire process. These other Ugandans, especially young people that have been arrested this week because they have been peacefully demonstrating against corruption in parliament, corruption in many government entities, and they were brutally arrested. Let's release these people on bail too. What government needs to do is to listen to them. Thinking that you'll be high-handed, brutalize them as you arrest them, and so on, it will not work. Because as you arrest others, the other day they arrested several of them, even today others came out and they've arrested them. Tomorrow others will come out. Listen to their concerns, address their concerns of this corruption that is skyrocketing every other day. Don't be like President William Ruto of Kenya, who woke up when it was too late, because the people of Kenya were saying this finance bill is bad, reject it, withdraw it. He refused. When the pressure intensified, he withdrew the bill, he dissolved cabinet. But now the young people of Kenya, they are saying, you see, you didn't even listen to us at the start. That means you're not a good leader. We want you to also go. And so the protests are continuing even after he withdrew that bill. Is that the kind of lesson you want to have? Listen to the young people. They are saying we need to deal with corruption. And good enough, this matter has been depoliticized. It's not just an opposition matter. I saw young people saying they belong to the NRM, they're also arrested. I saw journalists, artists, civil society, and so on, which is what it should be, because corruption is not a political matter. It affects all of us. Everybody is affected. And I would like to urge other sections of society, religious leaders, cultural leaders, civil society organizations, all manner of people and leaders, let's voice our concerns on the question of corruption, because it affects all of us. It doesn't have a political party that this party is the only one that should be talking about these issues. All of us should be up in arms, speaking about this matter, saying action has got to be taken. Thank you.
Any question? As the anti-corruption shadow minister, I definitely discourage anybody who is corrupt in this country. We do not condone corruption as Parliament of Uganda. That is why we have come and stand surety for these people. First of all, corruption is a vice that we are all supposed to fight. The youth, the old, the people with disabilities, the president, members of parliament, every leader, security officers, everyone is supposed to fight corruption. If we don't fight corruption, it is going to eat us all up. It is going to eat up all our country. We shall not be developed as we are supposed to be. Our children, our grandchildren, and our great-grandchildren are going to suffer because of corruption. Let us not see this as a war between the president and the people of Uganda, that it is the president supposed to fight corruption, so this are going to be, imprisoned or taken to jail because they have been fighting corruption. No, it is something that we should do collectively to make sure that this country gets to where it is supposed to be. Otherwise, if we don't fight, we are going to fail as a country.
Thank you. Your name is once again?
Nachimule Helen, Member of Parliament, Kalangala District.
Thank you.
Yeah, of course, I'm very happy that a president has been set today, whereby court has overruled prosecution's objection over my right to being a surety. Because as a member of parliament, as a Ugandan who is not guilty of any offense, I'm free to be a surety of anyone. So prosecution was objecting my being a surety. But of course, court has overruled him, and this sets a precedent in the whole country that whoever who is not guilty can stand surety. And I know I'm not one of those ones who are guilty of any offense in this country. So I thank court for being bold and standing firm and following the law as it is in this country.
First of all, we want to condemn actions of arrests to the citizens. You realize that on Monday, a number of political leaders, including Honorable Zaake Francis, Honorable Chimid Hassan and others, were arrested in front of the party headquarters. These are the colleagues who had come to attend to a press conference. But even though when the press conference was cancelled, Honorable Zaake is a member of National Executive Committee of the National Platform representing the youth. And with that mandate, he owns an office, he has an office at the National Party headquarters. But it was sad to see that police, the way they manhandled him, it wasn't professional. We want to beseech the authorities to respect rule of law, to respect the leadership. This was not an act of being idle and disorderly. We are coming to our offices to address the nation. Initially, we had requested for venue at Kololo Airstrip, and you blocked us. We saw it wise to come to our party headquarters because it is where we have always been having press conferences. But to our dismay, we saw police manhandling Ugandans, manhandling leaders, something that we condemn. And that's why we have come today to stand as sureties for our colleagues, because we know this is a constitutional right. This is a constitutional mandate, and we are glad that at least the Temple of Justice has granted them bail. Secondly, on the anti-corruption...
The accused were arrested near the National Unity Platform offices in Makelele, Kavule, protesting against corruption.